Okay, we'd like to welcome everyone today to the Salt Lake Chamber Colleagues Together webinar to talk about the next legal issues and concerns for businesses. We are very lucky today to have with us four very talented lawyers with some various practice areas to share with us their expertise in some of the areas that we're looking at now. As many of you know, as businesses, you've been so focused on moving through things and trying to keep up and making sure that you can address and save your business throughout this crisis. And hopefully what we're moving into now is a more stable time where you can actually start to make some plans and discuss how to move forward in a very deliberate way. And so today we have with us several lawyers who are going to be able to talk to us about the issues related to liability, employment questions, labor questions, your just corporate issues, your supply chain issues, and financial issues, what you need to do to be planning. We have with us today Mark Gaylord from Ballard, Spahr, Sean Monson from Parsons, Behle, Troy Keller from Dorsey, Whitney, and Sheryilyn Olsen from Holland and Hart, some of Salt Lake's leading law firms and some of our greatest experts here. As we get started, we're going to turn the time over first to Mark Gaylord, who is the managing partner at Ballard Spahr. His practice focuses on litigation, labor, and employment, and he's going to talk to us today about some of those very specific labor and employment and liability issues. So Mark, we'll turn the time over to you.
Let me take myself off mute and say thank you, Jacey, and good afternoon, everyone. As many might see, you may not see it, I actually am wearing a tie for the first time since February 21st. Upon returning from a ski trip in northern Italy, which is where much of the pandemic exploded outside of China, in early March, I found myself in a 14-day quarantine, returning to office on March 16th, the same day that we closed our office, and shifted in a single day, 900 lawyers and staff from working in offices around the country to all working from home. And as Jacey mentioned, I'm the office managing partner. And since then, along with other managing partners in offices and the firm's management team, we've now been facing many of the same issues I think each of you are likely facing as we evaluate and consider a myriad of issues about reopening, re-engaging our businesses. Some of you probably never closed as an essential business, but others are just reopening or already back in business, but facing daily issues that raise questions in your minds on how best to address the legal issues all employees face. The guidelines are plentiful. I don't have to remind you, you have the Families First Coronavirus Response Act, ADA, you have CDC guidelines you can look to. We have state guidelines that exist for us to look to. The governor's tiered guidelines are very easy to find on web, and I invite you all to look at it. You probably all have. But what do we as employers have to do to provide a safe working environment for our employees? What are the rights of employees to ensure they are safe in the workplace? For some businesses, such as law firms and other professional offices, there is an opportunity, at least in part, to safely and effectively work from home. So we can decide whether we want to do that. But there are those businesses, retail, restaurants, healthcare, manufacturing, even governmental operations that simply cannot operate from home and must be open. And how do we go about doing that? And I'm going to take the next 8 or so minutes and share with you some suggestions on what to consider as we head back to work and reopen. And like all good businesses, it starts with leadership. And so leadership is really starts at the top. It starts with the management making decisions. And one of the key components of that is establishing a team and or task force that will be overseeing the planning, execution, and monitoring of what you plan to do in terms of going back to work. Just opening for business is not going to be sufficient in today's marketplace. You have to conduct risk and hazard assessments. You have to create a reopening plan that for your business meets all of the CDC, government guidelines, et cetera. And if you are, and I put in here, if you're in a tenant or landlord relationship, it's important that you as a tenant, assuming you're the tenant, are communicating to your employees what the landlord's expectations are. And if you're a landlord, it's important for you to communicate what your expectations are for those tenants. And as part of the team or task force putting together those things, you must undertake those regularly, monitoring and updating it. And then I think you have to document it. And what I mean by documenting it is just make sure that you are keeping all of your employees informed. And as you formulate a reopening plan, there are many considerations, and health and safety are maybe at the very top of that level, and mitigation measures have to be put in place. Again, landlord tenant, if you are a landlord tenant, you are going to be traveling to and from your home to the place of business. There's many places, there's many touch points that are going to occur. Do you have doors that are electronic doors? How many people are going to be in elevators? What is your busy time? Do you have people coming in at a different time to avoid the congestion? We face that problem at our firm. We have an office in Philadelphia, our largest office. They're on the 45th through the 51st floors. We don't have that problem here as much in Salt Lake City, but you can imagine it sits on top of a train station, and so the concerns about management and mitigation become huge. You also have to take into consideration, and many of those in industries that have been operating since this pandemic started are looking at staffing and janitorial screening, how you clean your facilities at a time. As we all know, grocery stores today have ceased operating 24/7 in order to give them time to clean up the spaces and make those spaces available for their customers. The same is true of employers and employees, creating the workplace to assure that the employees feel safe and that the transition from a remote to an in-person operation operates in a meaningful way. And you also have to put together, as you put your plan, how you're going to recall and rehire, how you're going to ask employees to come back. What are the conditions? Are they going to be based on timeframes? Are they going to be tiered timeframes? And how? And then what are going to be the requirements for their returning? And as long as you communicate with them and consider you can consider those things. And also, I think I put this last point: retrenchment. What happens as the COVID spikes? Are we going to retrench and go backwards? You need to have in place what we do with those things. And some of the things that come into play with all these is you have to be prepared to deal with operational stuff about how to go about it. So you have to have policies and protocols put in place. A perfect example of that, and we were just talking about it today within our office, is how many people go to the bathroom at one time. You think about that as being such a minor issue, but what you don't want is having a number of people congregating. What are your hand washing and cleaning sanitations? Many offices have coffee stations. Many offices have break rooms. Are you going to have those cleaned on a regular basis? You need to consider in these protocols and make sure you're dealing with. Are you going to require everyone to wear masks? What are those requirements? And as you think about wearing masks, you're going to be faced with people who are going to think they have their personal liberties or their own health reasons where they can't use masks. So you need to be facing those kind of issues all the time. The idea is how you schedule breaks. What's your movement going to be? Are you going to have a one-way location or not? And then what is your emergency response plan? What happens when a client who comes into your office or a worker who comes in doesn't think he's symptomatic and suddenly suffers from illnesses or has been there the day before? How are you going to address it? Are you going to require those that he came into close contact with to remain quarantined for another 14 days? You have to think and have those considerations. And the COVID open door policy, and I'll talk about this a little bit more, is simply one of making sure that the lines of communication are open, that people can come to you and as management and as you open your business and be transparent so that there can be issues that are addressed. You also have to deal with ADA issues that will arise in terms of whether the workplace is such a circumstance and whether the idea of the face mask, as I mentioned before, does it impact somebody's health, and what are the ADA issues that are addressed by that. The next area that you need to be mindful of is the monitoring of the new phases. As we move through, and I mentioned this at the very beginning, it's important to monitor all of the various public orders and guidance plans that exist out there so that you are up to date and are coordinating your plan in a way that meets all those guidelines. We're lucky in the state of Utah in some respects. Some will disagree. In Colorado, for example, there's a requirement that everyone who comes into an office or into a building must be tested for their temperature. So you can think about, how do you go about doing that? Do you have somebody 6 feet away taking your temperature or not? How are you going to accomplish that, and whether you want to do that? And I also threw in on this a short comment about media and PR issues. You need to also be mindful that what you choose to do can find its way out into the media. There can be disgruntled employees who don't like what we're doing. There can be disgruntled customers who don't like what we're doing. Perfect example of that is Costco and other industries who have chosen to require anyone who's attending or using their business must have face masks. What impact are you going to have if that's a requirement you have by media or by somebody picking it up and having a negative PR issue? Another area that can mitigate some of the liability and the exposure that exists there are things like third-party agreements that you have with staffing agencies that might be providing you with work. If you have a third-party vendors who come in, how are you going to screen and test those third-party vendors to be sure that they are meeting the guidelines that you have created? And other ways of mitigating your exposure as a company, though, is through either the workers' compensation coverage or just having a general liability policy that provides that if there's an infection of customers, vendors, and third parties, you have coverage to assure that if your exposure is out there. What we're seeing on a more regular basis are companies. As you may know, the state legislature during the last session passed a bill, 78B 4517, immunizing businesses from COVID-19, but that's for willful, but there are exceptions to that, which include, it doesn't apply to willful misconduct. And as lawyers all on this WebEx will tell you, a good lawyer can always find sometimes a way around that exception and or present evidence. The key there is that if you dot your I's and cross your T's, you've given yourself a much stronger case against anyone trying to suggest that you acted in a willful and malicious manner. I also raised the fact that as we see the various guidelines being imposed, there's new postings and signs that we need to make sure are placed in the environment. As those come into play, OSHA has its industry-specific posters, DOL has them, and it's just important that you put those out and make sure that they're there as well. And finally, I'll just quickly broach on some just employee issues in the sense that the National Labor Relations Act protects certain activity by employees. So for example, an employee refusing to work based on safety concerns is a potential claim. And I think you need to be mindful as employees bring people back, whether or not the employee can work from home, and if the person can work from home and then suffers from potential conditions that put them at a higher risk, employers may be wanting to work with them. The problem you have is those employees who sometimes say, I'm going to invoke the health and safety of my own self, and I don't want to have to come to work because I feel there's a safety. What are the rights and risks? And Sean, I think, is going to address some of those things in just a moment, but you need to be mindful of things like sick outs. There's been several due to this pandemic, including Whole Foods. Those can have impacts. They're protected activity that can't be penalizing the employees for taking those actions. And so with that, I'll make one more observation, and that is we have a COVID-19 resource center you can get on our website. But I would tell you that everyone on this phone or on this WebEx is providing valuable resources through their webs. And so we're all here to help you. We're all here to be able to do it. This is a free service from the Ballard offers, and I invite people to use it and take advantage of it, or take advantage of any of the others that are offered by the good firms that are here today. And so with that, I'll kind of turn it over to Sean.
Unmute myself. I want to introduce Sean. Sean Monson is the Labor and Employment Chair at Parsons Behle, and is going to talk to us a little bit more about working with your employees, and particularly your vulnerable employees as they come back to work, but some more of those concerns as they're there. And as Mark mentioned, I've never seen another point in time when lawyers have been so willing to give free legal advice to the public. And I think this really does just reflect the fact that everyone's businesses are so interconnected. Everyone's ability to succeed and survive this is dependent on everyone else's ability to do the same. And so it's really remarkable to see these firms and others provide such public services. So Sean, thank you very much, and we'll turn the time over to you.
Thanks, Jacey. So I wanted to, before I begin my presentation, wanted to touch on a couple of things that Mark talked about. I'm going to give you an acronym, and the acronym is PPP. Now, I know a lot of you have heard PPP, and that acronym with the Paychecks Protection Program loans, the PPP loans that have gotten a lot of publicity in the media, and I'm sure a number of you have applied for those loans and are now facing the task of figuring out what certification means and figuring out how you're going to do loan forgiveness. But in this context, I want you to think about another PPP, and that is when you're developing a reopening plan. I can't reiterate enough what Mark said about the importance of creating a plan, and that is that is true whether you have been open or through this whole period of time, or whether you're just reopening. Because with these standards that are coming down from the federal government, the state government, it is vital to have a plan that makes sure that your practices are consistent with those guidelines. And so when you think about your plan, think about that acronym PPP, and that PPP in this context stands for people, places, and policies. And what that refers to is, people. What people are you going to bring back? As Mark talked about, are you going to phase them coming back? Are you going to have people come back based on their positions? And then you think about places, as Mark talked about. Go through and think about where people might be congregating, where they might have problems in keeping distancing. Think about your workspace, how you can maybe rearrange some of your cubicles so that people have more distance. And then policies, and that is creating policies regarding all the issues that Mark identified, and what you're going to do when certain things happen, what you're going to do if someone tests positive for COVID-19. All that needs to be thought through in advance and put in writing, communicated to your employees. And as Mark said, make sure that you document the communication process. I tell clients all the time, if it's not documented, it did not happen. And the reason why we're saying document this is if you have a situation where you might have a customer or an employee who tests positive for COVID-19 and you get sued, and as Mark talked about, there is the Utah liability statute, but there are exceptions to that statute. And if you get sued, the most important thing you're going to be able to show, your Exhibit A is going to be, well, here's the policies we had in place that were consistent with the CDC guidelines, and here's the documentation about how we communicated to the employees. So those things are really important. So I don't know if the slide, I had a couple of slides for this. We have those, Jacey, do you know? Okay, there we go. All right, can we go to the next slide? All right, so when we talk about vulnerable persons, or you can call them, sometimes people refer to them as at-risk persons, what we're talking about is people who are at risk for either being infected by COVID-19, or more specifically, I think most people use the term and talk about people who, if they get COVID-19, have a higher chance of having a more severe illness and potential hospitalization and potential death. And so who are we talking about when we're talking about vulnerable employees? We're talking about people who are usually considered to be 60 years old, 60 years or older, people who are immunosuppressed or compromised, people who might have been taking chemotherapy because of cancer, or who might be on other immunosuppressant drugs, such as Crohn's disease or rheumatoid arthritis. Also, people who might have heart disease, lung disease, kidney disease, cancer, diabetes, asthma, lupus, rheumatoid arthritis, which I mentioned, cystic fibrosis, Crohn's disease, AIDS, and severe obesity. One thing that I want to emphasize on this list of people who might be considered to be vulnerable or at risk is the list is always changing. And that's one thing that we found out about this during the COVID-19 era is that we really don't know what the answers are the answers are constantly changing, and this list is always changing. So it's important to stay informed, to make sure that you are checking with the CDC website on a regular basis, checking with the state of Utah's COVID-19 website on a regular basis, because things are constantly changing. The answers that you have today are not necessarily going to be the answers that you have next week. Okay, next slide. And one thing that is interesting about talking of vulnerable persons and at-risk individuals, I've been doing employment law for over 25 years. And if you would have told me a year ago that, I want you to go talk to employees and ask them about underlying health conditions and ask them about whether they're sick and ask them what symptoms they might have, that's just something you didn't do. And because of the restrictions under the Americans with Disabilities Act. The EEOC, which is the federal agency that regulates and essentially administers the anti-discrimination statutes for the federal government, they've come out with guidance for what questions they can ask during a pandemic. And that it goes to some of the things that Mark talked about, and you can ask folks when bringing people back to work. You can take temperatures. You can ask people about underlying symptoms. Those are all changes from the way the world used to be in employment law. And the thing that's interesting about the current federal guidelines and the state guidelines is that they essentially strongly encourage employers to go out of their way to try to accommodate and protect at-risk employees and their family members. And again, that is something that is unique. So as Utah goes into new stages, we've gone from red to orange and now to yellow in large parts of significant parts of the state gone to yellow. And then I've heard rumors that will potentially be going to green at some point. Obviously it will be, but that might be happening sooner than later. But as we go into each one of those stages, it's important to make sure that employers are mindful and take steps to try to accommodate and essentially protect those who are at risk. Special accommodations for those employees should be made at the workplace if they're unable to work from home. So let's go to the next slide. So what does the law allow and what does the law not allow? So under the Americans with Disabilities Act, which is kind of the main statute that governs this topic, you can't necessarily treat someone 60 years old or differently without their request. It could be age discrimination. If you treat someone differently who is pregnant, again, without their request, it could be pregnancy discrimination. If you're treating someone with an underlying condition differently, again, without their request, it could be disability discrimination. Asking someone about their underlying conditions could violate the ADA. Now, the EEOC has drawn a distinction between asking someone about symptoms they might be having of COVID-19 and the underlying condition. So asking someone about lupus, asking someone about hypertension, asking someone about their heart condition might be, and it could be a violation of ADA. Asking someone whether they have had a fever, asking someone whether they've had a cough, asking someone whether they've had chills, asking someone whether they've had difficulty breathing, which are all symptoms identified by the CDC as indicative of COVID-19. Those types of questions are not. So you need to kind of draw a pretty distinct line between asking about symptoms of COVID-19 before employees come to work, and even when they are at work, asking if they're exhibiting symptoms, asking about symptoms versus asking about the underlying conditions. Asking about symptoms is acceptable. Asking about underlying conditions is generally not. Next slide. So what if you've got someone who is in one of these at-risk categories, what can you do? And what should you do? Well, the first thing and most obvious thing is that if they say, well, I'm uncomfortable coming back to work because I have one of these conditions, to the extent possible, continue teleworking. A lot of people have been teleworking. A lot of employers have been having their employees do teleworking. And frankly, I think for a lot of employers going forward, this is going to be a more and more acceptable practice. I was talking to a client the other day, and they're coming up on a lease renewal, and they said, we're not going to renew the lease. We don't need as much space. Teleworking is working fine for us. It helps us save on the bottom line. So we're not going to, continue the lease. We're going to shrink our footprint, our office footprint. So thinking about, if you can, one of the first and easiest ways to accommodate individuals is if teleworking is a possibility, have them telework. Allowing flexibility to the extent possible. Maybe if they can't telework all the time, trying to be flexible with when they do come into the office, when they do their work, so that they're not as exposed to other people, maybe different shifts, maybe different times, different work schedules. Just consider to think about maximum flexibility when you are dealing with these employees and dealing with their accommodation requests. One other suggestion is, if possible, you might use a volunteer program for those wanting to come back to work. There are a number of individuals who want to come to work. They come back to work. They don't want to telework. They want to come back into the office. And if it works for your company, think about having a volunteer program so that people who want to come back to the office, come back to the office. People who don't and want to stay at home and continue to telework, do that. Let employees know that they can request an accommodation under the ADA or your own policies. And those can be, some of those accommodations could be, again, teleworking, extra cleaning, extra social distancing, changing the job they do, changing the schedule, thinking about ways to have them not interact with the public as much or with their fellow employees as much. I think the key takeaway from this is try to be as flexible and as creative as possible to minimize the potential for one of these individuals in an at-risk category to be exposed to the virus. And then the last thing, and Mark mentioned this, is the Family First Coronavirus Response Act. I have been really surprised as I've been consulting with clients, particularly because our firm has done a number of webinars, and similar to Mark's firm, we have a COVID-19 response page. We have done a number of webinars, it's probably 20 or 30. We've done a number of articles about these issues, and we had a number of articles about the FFCRA, and still a number of clients don't know that it's out there. And so I would just recommend that if you don't know what the FFCRA is and what it requires, look it up or talk to your counsel and find out. The other thing that I've been really surprised about is that even employers who do know what the FFCRA is, a number of them have not implemented policies talking about how the FFCRA is going to be implemented and administered at that workplace. Most employers have thought, well, I've got my, I put up the poster that the DOL asked me to put up, that's sufficient. It's not sufficient. The regulations under the FFCRA give the employers a fair degree of flexibility and give them options about how they're going to administer FFCRA leave rights when an employee requests those. And that flexibility and those options are not outlined in the poster. And so to maximize your flexibility and maximize your ability to effectively manage FFCRA leave, talk to your counsel, find out what those options are in the regulations, and create a policy and distribute it to your employees. So that way they have the expectations to know how the policies are going to be administered, and your HR department has those expectations clear as well. And I'm sure any of the folks on this call can provide you with policies. We've been giving policies to our clients as well. Okay, next slide. Okay, this is one thing to think about when you're talking about accommodating folks who are at high risk, they can self-disclose their disabilities and request accommodations. And then just like any other ADA accommodation request, the employer has to engage in the interactive process. Meaning you talk about, you interact with the employee, you engage in a process where you try to figure out what accommodations are going to work, what's not going to, what accommodations are not going to cause an undue hardship on the employer, and just have a back and forth to see if you can come to a mutually satisfactory place where the accommodation requested by this individual meets their needs and also meets the employee's needs. Next slide. Okay, so this is an interesting question. There's two interesting questions. The first interesting question that we've been dealing with is first, what if an employee refuses to work? What if an employee says, I do not want to come to work, I do not feel safe? The first comment that I'd make is proceed cautiously. Talk to the employee, engage in that interactive process, figure out what the issue is. If ultimately you find out that they have a ADA qualifying disability, then you need to go through that interactive process under the ADA to find out whether there is an accommodation that can work for them that would not cause you an undue hardship. If there's no ADA issue and the employee is simply scared to come back to work, you can't take action. I know that Mark talked about the NLRA, and obviously you need to be cognizant of those obligations. But under the ADA, if the employee does not have a disability that qualifies under the ADA, they simply say, I'm not coming back to work. Fear of coming back to work because of the coronavirus is not an ADA qualifying disability. The last thing I'll talk about, which is an interesting problem that I've been dealing with for a couple of clients, is employees who are at risk say, I don't want to telework, I want to come into the workplace, I don't care. I'd much rather come into the workplace, I don't want to stay at home. And even though they're at risk, they're in an at-risk population. What do you do in that situation? Well, what we've been telling our clients and how to address this is, try to figure out a way to minimize the risk that employee might have of contracting COVID-19. And that would go back to some of the things we talked about earlier, figuring out a way to maybe have that employee physically distanced from other employees and other customers. If the employee has to interact with customers, using some of the like plexiglass barriers and other barriers you've seen. Maybe have that employee switch jobs where they don't have to interact with the public as much, or don't have to interact with employees or other employees, or alter their shifts to avoid that employee having to have contact. But those are some of the things that if an employee says, I still want to come back to work, it's a little bit of a tricky situation because the state and the federal government is telling you, we want you to protect these people, and that person saying, I don't want to be protected. So those are kind of some of the steps that we've recommended to our clients about how to address that, and that is figure out a way to try to protect that individual as much as possible. So with that, thank you, and if you have any questions at the end, I can either take them now or at the end. So.
Thanks so much, Sean. I think we're going to save questions for the end for this one, and there will be lots. We're next going to turn the time over to Troy Keller. Troy is fairly new to Dorsey and Whitney. He joined them after 15 years with 2 Fortune 500 companies. Troy's specialty is dealing with corporate law matters just in general. So Troy's going to walk us through some of just those very important business issues that we all need to focus on. Thanks, Troy.
Awesome. Thanks, Jacey, and thanks to you and the chamber for the opportunity. I didn't go as far as Mark and put a tie on, but I do feel great having just an excuse to be having a collared shirt. To be honest, feels great. So again, thanks for the opportunity. So we're going to shift the focus a little bit to the supply chain, and think about that as sort of your commercial arrangements. So companies, these are your commercial relationships with your vendors and your customers. Maybe those relationships have a contract behind them, maybe they don't. We're going to talk about some of the some of the headwinds and the issues that companies seem to be facing now more than ever with COVID, and in particular with COVID, and maybe some thoughts on how to address those. So let's see. Excellent. So this first slide, I tried to capture some of the trends, just to sort of to step back a little bit and give a sense for what companies are up against right now. And for those of you listening, most of these are probably no surprise to you, but maybe to talk about them in one shot kind of helps provide some perspective. And obviously, no contract, no commercial agreement could have contemplated all the things that are happening right now on the commercial side. And even if you're putting in place a new contract right now with a supplier or a customer, there's still significant uncertainty in the market. So this isn't about having your contracts be perfect. And it's not about being able to enforce the letter of your contract. This is, what do we do in this unique situation that we find ourselves in, and what are some practical advice and definitely some legal concepts that you might want to have in mind. So by way of background, a few of these issues, working capital is an issue that we saw this in 2008, 2009. Companies are just aggressively, when they're not in growth mode, when they're in protection mode, companies are going to aggressively protect their liquidity. And so, you see this, and companies will say, look, yes, they'll sheepishly say, yeah, we're pushing out our payables as much as we think we can get away with, but we're only doing it because everybody else is doing it, and our customers doing it to us, so we're doing it to our vendors, and look, it's happening everywhere. People tend to be pushing out their payables as much as they can, and no, it's not. In a lot of cases, it's not legal under the contract that you have or the course of conduct that you've been operating under. But people are willing to put a little pressure on relationships in times like these, and that's where judgment comes into play, and how much makes sense to do, is fair to do, and you can get away with doing. Okay, the next issue here, industry disruption. We've all, again, no secret that some industries have been impacted much more significantly than others: travel, automotive, retail, oil and gas, etc. And there have been some government, focus and intervention in some of those, but it's not perfect. So what that means is that your industry, if you're in one of those industries, well, you're in the center of the hurricane, and you've probably been focusing on all your options already for some time. For others, some of those businesses that maybe weren't essential and are getting back into business now, you are trying to figure out how these maybe related industries are impacting what you're able to do. For example, if in a lot of industries, you've got to travel a lot. I know that people are finding great ways to work remotely. In some cases, you've got to go, you've got to oversee a construction site, for example, or you've got to go, there's an issue at one of your plants or facilities, or one of your customers' facilities. You just got to be there. So again, travel comes into play, logistics come into play, and is it an excuse under your contract that basically says you have to be on site if you can't get a flight? So those are some of the things where the legal meets the reality of what's happening in the industries. Next area, super interesting, kind of from a policy standpoint, but again, it is impacting commercial relationships quite a bit, and I'll explain why, or at least the prospect of some of these shifts on the policy side. COVID, again, no secret, has elevated the rhetoric between the U.S. and China. It hasn't, to be fair, it hasn't actually changed any of the trade relationships that are in place, or obviously trade policy was already big news between the U.S. and China for a long time. But the phase 1 deal remains intact, and And no amendments have been made to our antitrust laws or CFIUS since COVID that would make it harder for China to operate in the U.S. However, there's been a lot of talk of that. There are Buy America policies that President Trump has put out there, in particular around like medical PPE, that sort of stuff. There have been a lot of calls for the regulators to be tighter in their enforcement of antitrust and CFIUS. And we are, and interestingly, it's not just in the U.S. You see this. I've got a list here. I just did a little bit of Googling earlier today. In just the last few weeks, basically since COVID, you've got the UK, India, Germany, Canada, and Japan have all either have announced that they're enacting or that they're starting processes to look at enacting sort of tighter restrictions on investment, and all sort of focused on China. So again, a lot of possible stuff happening in the U.S., a lot of stuff happening internationally that is going to make it harder for supply chains that are backward integrated into China. And so again, from the micro perspective, for your company, you look at your supply chain and you say, yeah, a lot of our stuff originates in China or flows through there. And I am of two minds of this. I think that a lot of this could be fixed pretty quickly. So while some companies are saying, yeah, we got to get out of China, we got to move our supply chains, that is certainly, I would say, the conservative thing to do if you can do it. However, maybe a smarter approach might be to just keep as much flexibility as you can in both your contracts and in your commercial strategy. Keep some flexibility there, because I think the future with respect to the global supply chains is obviously still to be written, and I don't think we can quite predict how it's going to go. The last point I'll make on some of these trends is the phased opening of the economy. And really the main point there is that as the economy opens, I think it was mentioned earlier, we might have a spike or an outbreak that puts the economy backwards a little bit. And so while things might have been open, then they're closed. You can use the excuse of COVID for an existing contract, and it may well work once, but it's not going to work twice, right? Because right now you can say COVID was unforeseen, and maybe it does work as an excuse, but in the future it probably won't. So, okay, let's go to the next slide. So some practical tips on what you can do now. I would say that in the interest of time, we'll just kind of boil it down into a really rough overview of these legal principles. So be strategic is kind of the main point. Get a working team together. I know that's not super original, but it is critical. Kind of like we talked about before in terms of having a plan. Create a plan so they don't fight a contract where, in fact, it may not be a priority for your company. So, work with your business team, your legal team, your finance team, your logistics team. And then keep in mind, looking here at the bottom of the slide, I've listed out some of these dusty legal concepts that sure companies face them from time to time when they're trying to enforce a contract, and they can be used as excuses to not have to perform under a contract. But I tell you, these days, a lot of people are looking at them very closely. And if you're somewhere in the middle of the supply chain, or most anywhere in the supply chain, you've got some pretty big contracts that you are relying on, or that people are coming after you on. These are principles that you should probably get educated on pretty quickly. Most of them are concepts of law. Force majeure is a contract provision. One interesting point there: if your contract has a force majeure clause in it, one debate that we've seen happening quite a bit is, well, does the clause mention pandemics as an excuse to get out of your contract, or to excuse performance? And most clauses don't have epidemics or pandemics listed, but most do mention government action. So if you were shut down because of the government, maybe that works under the force majeure clause, depending on which side you're on. That might help or hurt you. Impracticability, frustration of purpose, those are things that again, You can say, look, COVID has made it impracticable for me to supply under this contract. It was unforeseen. No one could have foreseen it. It goes to the heart of the agreement. That's an excuse for me. Or on the other end, your customer might come to you and say, look, I'm a retailer. I don't need those t-shirts that you make. That I know I promised to buy them from you, but I can't sell them. The whole point to our agreement was that I'd be able to be open. The government shut me down. So purpose of that agreement has been frustrated. Last one, economic duress. Super interesting. Usually very rarely a justification for getting out of a contract. But basically what it says is if you're in a contract and your counterparty says, hey, I'm going to, I'll never buy from you again. I'm going to tell people that your products are junk if you don't, lower your price given the COVID circumstances. You may be able to get out of that later on down the line. So using that principle. Anyway, a few things to be thinking about and throw out there for you. Again, a lot of resources out there, and I will turn it back to Jacey. I think you're on mute still, sorry.
I think we get this done. Thank you so much, Troy. And finally, we have Sheryilyn Olsen. Sheryilyn is an attorney with Holland and Hart. She's a partner there. Sheryilyn's practice focuses more on advising lenders and borrowers. She has a large bankruptcy practice, which is what we're hoping to avoid. So Sheryilyn's going to give us some great tips about how to manage these kinds of things, to manage your company through. So Sheryilyn, thank you.
Thank you, Jacey. Now that we're trying to figure out our new normal and businesses are beginning to reopen, what can be done about the obligations that piled up during the shutdown or obligations that will begin to pile up as the economy begins the recovery process? Well, I'm going to talk about three primary topics. The first one is strategies for working with your creditors when you owe other people money. The second one is strategies for working with your customers or clients who may be struggling and owe you money. And then the third one is going to be strategies for what to do if a customer or a client files for bankruptcy and you're a creditor. And due to the time constraints and the fact that my topics are fairly boring, I'm not going to be able to go into a lot of depth. But hopefully you will leave this webinar with some things to think about, and hopefully I can at least point you in the right direction. Let's start with the first topic, strategies for working with your creditors. There's all sorts of options you have available to you. None of these are a 1, 2, 3 step process. Think about them as various tools in your tool chest that you can look to trying to resolve some of the obligations you may have with your creditors under this new environment. The first one I want to talk about is communication. You will be surprised with how much people are willing to work with you during this difficult time, and communicating can really give you some breathing room and some opportunity to delay things as you try to get your feet back under you. Things are changing. Lenders, creditors, they're all still working through their own plans, and you can usually buy some time for you and your business simply by communicating with them, asking questions regarding your options, and keeping them posted on your plans and how things are evolving. This typically can give you a 30 to 90-day solution potentially with creditors, maybe even longer if you've got long-standing relationships with your creditors and they're willing to continue to work with you. A more formal step is what's called a forbearance agreement. This is really kind of a 3 to 12 month, maybe 18-month solution. And this works in all sorts of debtor-creditor relationships. It works with your landlords, lenders, vendors, and it's an agreement that sets forth in writing a temporary arrangement when you're in default. And this can really take two forms. It can be temporary relief that results in a return to the original loan terms, or it can be temporary relief that results in an exit of the relationship, provides you with an opportunity to find a new lender or new vendors going forward. The forbearance agreement option is great because you really have a lot of flexibility. You can negotiate new interest rates, you can negotiate a reduction of principal payments temporarily, or maybe even eliminating principal payments for a period of time, step up principal payments. It can be a waiver or a forbearance from enforcing certain financial covenants, whether those are financial reporting covenants, EBITDA requirements, fixed coverage ratio requirements, senior indebtedness ratios. Sometimes you might not be in monetary default, I mean, you haven't missed a payment, but these covenants are a real issue because the overall profitability of your company has struggled during this time. And a forbearance agreement can provide you with relief from those. It can also include waivers or deferrals of late fees. And it can include long-term discounts or adjustments if you're able to reach certain benchmarks, which will allow you some more long-term relief. For example, the easiest ones I think for creditors to waive are late fees, default interest, attorney's fees and costs. And if you satisfy the terms of your forbearance agreement, some lenders are willing to let all those go as long as you've satisfied those forbearance terms and can get your business back in line. So those are things to think about. The next option, or an option that's also available to you, is long-term loan modification or contract relief. This is really a long-term solution that permanently changes your contractual relationship or your loan facilities with your creditors. This can include all new financial covenants or no financial covenants at all, a new payment schedule, a new amortization, new interest rates, new terms on how that debt will be repaid over time. But it really is it's a permanent change to your existing contract relationships. Let's talk about one other option. No one likes to hear this word as it relates to their own business, but let's talk about bankruptcy. There are options for you to operate and continue to turn your business around and rise from the ashes without just closing it down. That comes in the form of what's called Chapter 11 bankruptcy. The advantages of this are if you have creditors that are just not willing to work with you, but you really believe there's a hope for your business in the future, if you can just buy some time, Chapter 11 is a real option for you. You can continue to operate your business through the bankruptcy process in the ordinary course. The automatic stay comes in place, which prohibits creditors from taking litigation, collection, or going in and taking back their collateral. It gives you some real breathing space to allow you to figure out a long-term plan that will let you pay your creditors over time and will really let businesses kind of rise from the ashes with a clean slate and move forward. Let me tell you about a couple changes that have recently happened is March of this year that can really provide some advantages in the bankruptcy realm. Small businesses have some added protections in the bankruptcy code that allow them to file a bankruptcy reorganization in a much slimmer, cheaper, more expeditious process. And the cap prior to March was that you only qualified for this small business plan of reorganization process if you had less than $2.7 million of debt. However, in March, under the CARES Act, that cap was expanded to include businesses that have less than $7.5 million worth of debt. So that's a really higher bar that allows a lot more businesses, smaller businesses, to qualify. The advantages of this small business bucket or categorization allows you to complete the bankruptcy process in a shorter process. It allows a private trustee to come in and help advise you on how to reorganize. No unsecured creditors committee will be appointed, which makes it a lot cheaper. There's no voting on the plan of reorganization, which also makes it cheaper and faster, and it allows you to get a plan confirmed as long as it's fair and equitable, and you commit all of your disposable income for the next 3 to 5 years to funding this plan and paying back creditors. So although bankruptcy may sound terrifying or something that's scary, especially when we're in a pandemic that's affecting businesses all over the world, I think a lot of the stigmatism that comes with bankruptcy is gone. And it really is a viable option for allowing your business to, if your creditors are being really aggressive, gives you an opportunity with protections by the bankruptcy code to reorganize and get things back on track. Let's move strategies here and talk about strategies if you have customers or clients that aren't being able to pay their debts as they come due to you, and that's going to impact your own cash flow going forward. The first step is communication. Does that sound familiar with my advice from dealing with your own creditors? Communication is key. It will help push you up the priority list of your own customers and clients, and it will help you better understand their current situation and will help you make plans for your future and give you more predictability in assessing your own potential cash flow when you better understand where your customers and vendors are coming from. If that process is unsuccessful, or if you need to step up the game in order to get more money coming in the door, I recommend starting with a demand letter. Start it on your own. You don't need to hire a lawyer for that. It can be informal, it can be an email, but get something in writing where you're making a formal request to your customer or clients that says, hey, you're behind, we really need to get a plan in place. for your repayment of this debt. We understand you're going through difficult times. We'd love to work with you, but let's talk about that and try to get something in place so we can both be successful going forward. The second step in the demand letter bucket, I would say, is to hire an attorney. You'd be surprised how much more responsive a customer may be once a lawyer's letterhead shows up. That means that you may have had a customer or a client go dark, and then all of a sudden they get a letter from a lawyer and they're on the phone with you or sending you an email. That may be all you need. You may just need the lawyer to send the letter for your customer and client to move you up the priority list and start communicating with you and working with you on getting back on track to getting you paid. Let's talk about the next realm. That's negotiating repayment terms. When you're negotiating with your customers and clients, you should be negotiating not just keeping the existing bills current, but also payments that include becoming current on the old obligations that are owed to you. Your repayment terms should include both concepts. If you're really concerned about whether or not they're ever going to be able to bring you current, or they need a lot more time to bring you current, you can start approaching them about having a discussion about whether or not you can secure some of the amounts owed by their assets. Do they have real property you can get a deed of trust in? Do they have personal property they're willing to pledge as collateral? Becoming a secured creditor puts you in a much different negotiation strategy and protects you better going forward. And it might be time to start having those discussions if the debt is becoming very stale and you're worried about their long-term ability to pay. Another option you might want to consider in discussing negotiating your repayment terms is whether or not they are willing to provide you with a guarantee. Are there owners and executives willing to stand behind their company during this difficult time and guarantee the obligations that are owed to you? This is something that might not make sense if they don't owe you a lot of money, but if we're starting to look at critical vendors and customers that are going to directly impact your ability to stay in business, this is something that should also be on the table to be considered. Let's talk about some of your legal remedies. If you're a landlord, you've got eviction options. It's a pretty short process in Utah to move forward with eviction. Keep in mind that Utah is not a self-help state. You can't just go in and change the locks. You've got to follow the statutory process of serving a notice to pay or quit. Then if they don't comply with that, moving forward with an eviction action or an unlawful detainer action. Foreclosure, if you have real property collateral, it's a 4 to 5 months non-judicial process in Utah if you've got a deed of trust. If you have personal property as collateral, it's really quick under the UCC where you can do a 10-day private sale process or a public auction if it's something that makes more sense to sell through a public process. Another option that may be available to you is a receivership. You may seek through a litigation process. If your contracts do or don't provide for it, you can ask a court to appoint a neutral party that can operate that business and or liquidate the assets. So they can operate it as an ongoing concern. They can also come in and start to sell assets and repay creditors. There are other options too that you can maybe work with your vendors and customers that are in trouble and encourage them to seek the voluntarily bringing in a temporary CFO or restructuring officer that doesn't require a court process if they're cooperative, that can help them get their finances back on track, and as part of that agreement can provide you reporting so you have a better idea of their financial picture and where they're headed. Litigation is always an option where you can then bring a lawsuit and sue customers or vendors to get repaid. You know, this is a process that I wouldn't recommend for someone you want to continue to do business with long term. People don't tend to want to do business with people who sue them. So this is really an option that I would only recommend if you've moved into a route where they don't have the ability to pay you or they're closing their business. Another option, much more extreme, is looking to an involuntary bankruptcy where a group of creditors comes together and forces a business to enter the bankruptcy process and to pay creditors over time or to liquidate their assets. Okay, we are out of time. Let me tell you about the fourth one real quickly. Let me at least tee up the issues for you, and then if you've got questions about them, let me know. Step one, can I still be paid money that I'm owed if someone's filed bankruptcy? The automatic stay stops you from going and pursuing your collection remedies against that customer. You can get relief from stay in certain circumstances. You can also file what's called a proof of claim that evidences your claim to the bankruptcy estate. And to the extent there is money to distribute creditors, you would be in line to receive a portion of that. That form's available on the bankruptcy court's website, and you can file that on your own without having to hire an attorney. Another question I hear a lot is, can I get my stuff back? The automatic stay says no, not without getting court relief. But I wanted to at least tee you up on one issue called reclamation. If you've delivered product within 45 days of a company filing bankruptcy, you have special rights and remedies that are available to you where you can get that product back, but you have to act very quickly. You have to file that reclamation notice and take steps within 20 days of that bankruptcy case being filed. There's a whole bunch of steps you have to follow. I don't have time to cover those, but if you've got reclamation questions, let me know. Third question, can I still do business with customers after they file? The answer is absolutely yes. If you want to still continue to work with that customer post-bankruptcy, you can do that if they're in a Chapter 11 reorganization process, and you'd be entitled to a higher priority of the repayment for post-petition work and services performed. Last one that no one likes to hear, the debtor, you have a customer or client that files bankruptcy, they owed you money pre-petition, and they made a payment to you within 90 days of filing bankruptcy. And all of a sudden you get a demand letter that says, you need to repay me that payment back. What the junk? It's called a preference. No one likes them. People get so angry about it, and I get it. They owe you money and they still want you to pay back payments they made to you shortly before you file bankruptcy. It's called a preference. It's a bankruptcy issue. It's by statute. There are lots of defenses you can assert to that demand, and you should absolutely consult counsel about that before you just write a check back. There's defenses that mean you won't have to pay anything back. And at a minimum, you should be able to negotiate a smaller repayment. So in closing, I know that's a lot to cover in 10 minutes. We've only scratched the surface. But the good news is that this is a global crisis, which means businesses are much more willing to work together because we're dealing with things that are unprecedented. And so there is hope of creditors and borrowers working in ways that they've never had to win before, and hopefully working towards win-win solutions. So hang in there, and if you've got questions, please feel free to reach out to me.
Thank you so much, Sheryilyn. Thank you to all of our panelists. We are out of time, but I am going to just take a liberty and ask just a couple of questions if you all can hang on with us, and if people need to leave, they can. But just real quickly for you, Sheryilyn, just what steps, if someone needs to, they're seeking an overdue payment, what would you recommend as far as documentation or protection for your business as you're seeking those kinds of payments in this environment?
Wonderful. I would start a phase process where your first communications, especially if there's someone you want a long-term relationship with, that you just start with phone calls or gentle emails asking them. I would up that game if they are going silent or not getting back to you or not taking steps to get you in the priority of payment line. And that would be a formal written demand letter where you send them a letter that says, here's the terms of our agreement. You're required to pay within 30 days. We haven't seen anything from you. Please get back to us within X days and if X amount of days. And if you fail to do that, we're going to pursue our legal rights and remedies. So I would start with a soft touch of even just a phone call or an email, and then up it if you hear no response. And then I'd reach out to a lawyer if your formal demand letter brings no response. Then I'd reach out to counsel and have that formal demand letter. That demand letter alone on lawyer letterhead may be all you need to get them to start paying or working out terms. You might need it might not need any other steps past that. So I would really encourage you to consider a step process.
Okay, thank you. And then one other just final question here is, we talked a lot about bringing employers back to work, employees back to work, making your plan, having a phased process as you're doing that. I pose this question to anyone who wants to chime in to answer it, but what, a lot of these plans presume an office type environment, right? An area where you can bring people back. What do you do if you are a manufacturing plant or a agricultural business or a kind of place where you can't keep people separate? It's a different type of environment that the work can't be done from home. Do you have any recommendations in those areas?
Yeah, this is Sean. I'll just jump in real quickly and then let anyone else who wants to respond. I think the first priority is what Mark talked about, and that is following the CDC guidelines, following the state guidelines, because they're not just, those guidelines are not just limited to office workers. They also have guidelines, and OSHA has guidelines related to manufacturing and other type of industries. So do that. Practice social distancing to the extent you can, and look at PPE. Face masks and other types of PPE protections that can help insulate or protect employees so that they're not as exposed to the virus as they otherwise would be without the PPE. But those are kind of the things that I would think about. But the main takeaway to me is follow the CDC and the state guidelines and OSHA guidelines.
Fantastic, thank you. Anything else? Mark, you're on mute.
I would totally agree with what Sean says. And you have to be mindful. I mean, manufacturing is a perfect example because you're going to have businesses that roll in and out or employees that roll in and out. So you're going to have a little bit of downtime. And CDC and OSHA has created guidelines that you must follow. And it's all about making sure that you've provided the safety to your employees while at the same time allowing your manufacturing business to continue to operate in the normal course. It's just simply more difficult and time consuming. You're not going to have the same necessary productivity in the manufacturing business or even in the, think about the meat packing business where they're meeting regularly and they're close in contact. There's a slide that of a company that sells sandwiches, and sometimes you don't even know if that sandwich that's been made has been made by somebody with COVID-19 that doesn't know about it. So you have to really be mindful, even for restaurants who want to get back to work, and you have to follow those CDC guidelines to ensure that you're following and complying with them. So,
thank you. Again, I want to thank all of our panelists, Mark, Sean, Troy, Sheryilyn. Thank you for sharing your expertise. It really is remarkable that you'd be willing to spend the time not only to prepare for this, but to do this in this really remarkable time. We recognize that there are lots of questions. We also recognize that as we move forward, there will be lots of those emerging legal issues, and the concerns of businesses from day to day will be changing and shifting. We will be continuing this series to bring you those answers, and look forward to working with all of you. Again, if you have questions, feel free to let us know and we'll try to address those directly. But thank you all for being here with us today. And again, thank you so much to our panelists.
Thank you, everyone. Thanks, Jacey.